on local government elections and pensions to order. Matt, would you please call the roll?
Senators Black.
Here.
Henderson. Here. Beck. Here. Bratton. Berger. Here. Crawford. Here. Nicola.
Here.
Nuremberg.
We have established a quorum. I move we go into executive session. Do I have a second? Okay, I have a second. All those in favor say aye. Aye. Those opposed, same sign. We're in executive session. I move to bring up Senate Bill 217. Do I have a second? I have a second. Senate Bill 217 was heard a few weeks ago. It's the bill dealing with foreign ownership of agricultural land. I do have a Senate committee substitute ending in .02C, which was distributed last week, and I move for its adoption. Do I have a second? I have a second. Is there any discussion before we vote on the substitute? Seeing none? Senator Beck.
Yeah, just real curious. You just limited this to foreign adversaries, right?
That is true. It was on the research portion of the bill, where a company to own property for research purposes, then we're using that list to ban them from being able to do that, purchasing any new.
So that's okay. So that's only on research. So other research companies that are not in the list of whatever.
On that federal list, yes. And Matt did the work with other people to try to find a list that the federal government names can change on it. It's kind of like, I know in the pensions world we talked about that OFAC list of who people can do business with. So it's a list like that that Matt has worked with people to come up with to identify those people. And it does change, which some people will be opposed to that, but that list could change.
Okay. I was just curious about that, and then I may talk to you at some point about another amendment, possibly for the floor, but I'll do that later.
The floor?
Yep.
Yes, yes. Senator Nicola.
Yeah, thank you, Mr. Chairman. I appreciate the sub to keep our foreign adversaries out from owning our land. And I talked about this when this bill first came up. That I think we need to put a limit even on the research of foreign companies owning our land, even for research. But we can talk about that later too. I just want to say thank you for at least adding our foreign adversaries to this, that they can't own our land for even research. So thank you.
Thank you, Senator. Any further discussion? Yes, Senator.
Thank you, Mr. Chair. I have a lot of issues with this bill. I'm going to vote for it out of committee, but you and I sit on that Southern Legislator Conference Ag Committee, and we're still going through the courts to kind of figure out what's really going to work and what's not. And I'm a little uncomfortable doing anything till we figure out what's really going to stick, if you will. But so I do have some issues, but I'm going to be a yes today. That may change in the future, but you already know that.
Well, Chairman Crawford, right? Is that happened yet, or does that happen
it will
this summer?
Yes.
This summer, yes. And I did have Tom, that the two of us know who I'm talking about,
Yes.
did provide me some more information, but I didn't get it until I think it was Friday when it come up.
Great.
So
would you share that with me?
We will have to look over that and see what that group says is the best step forward. And
Great.
I realize from your past, thinking about telling a farmer what they can and can't do with their property also causes some.
It does.
Yes.
Well, I appreciate it, and I'll look forward to getting that info. Thank you.
Thank you. Any other discussion? Senate Bill 217, the sub. Now we're going back to the sub. I have Senate Committee sub ending in .02C, which was distributed, and I do have a second. All those in favor, say aye. 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 Anyone opposed, same sign. That motion passes. I move that we do pass Senate Committee substitute, Senate Bill 217. Do I have a second? I have a second. Matt, would you please call the roll?
Senators Black.
Aye.
Henderson. Beck. Bratton. Berger. Crawford. Nicola. Nuremberg.
By your vote of 7-0, you have due pass Senate Committee Substitute for Senate Bill 217. Okay, folks, we're going to 104. I move to bring up Senate Bill 104. Do I have a second? I have a second. I have a committee substitute ending in .03C. Was distributed earlier.
Mr. Chairman, I kind of forget the order we do this, but I have an amendment to the sub that I've already talked to the bill sponsor, Senator Bernskoetter, about. It's adding the city of Nevada to, they want to be able to send before their voters an authorization of a public safety sales tax, and that's what the amendment does, and I have okayed it with the senator.
Okay. Senator Crawford has offered amendment to the Senate Committee Sub SB 104. Any senators have any questions? Discussion about the amendment? Do we have a second? Second. We have a second. Again, any discussion? Seeing none, we're going to vote on the amendment. All those in favor of the Senate Committee amendment to Senate Committee substitute for Senate Bill 104, say aye. Aye. All those opposed, same sign. The amendment passes. I move that we roll the amendment into the Senate Committee substitute. Do I have a second? Second. I have a second. Is there any discussion about this motion? Seeing none, all those in favor of rolling the amendment into the Senate Committee sub, please say aye. Any opposed, same sign. Motion carries. Now we're back to the Senate Committee Substitute, Senate Bill 104 as amended. Is there any further discussion upon that? Seeing none, we are ready to vote. Adopt this. What? Adopt the Senate Committee sub as amended. All those in favor, say aye. Aye. Anyone opposed? I move that we do pass Senate Committee Substitute, Senate Bill 104, as amended. Do I have a second? Second. I have a second. Matt, would you please call the roll?
Senators Black.
Aye.
Henderson.
Aye.
Beck.
Aye.
Bratton. Berger.
Aye.
Crawford.
Aye.
Nicola.
Aye.
Nuremberg.
By your vote of 7-0, you have due pass Senate Committee Substitute for Senate Bill 104 as amended. Now we're going to go to 388. I move to bring up Senate Bill 388. Do I have a second? I have a second. I have a Senate Committee Substitute ending in .03C, and I move for its adoption. Do I have a second? I have a second. Is there any discussion on Senate Bill 388? Senator Beck.
So, Mr. Chair, as I was reading through on the substitute on this bill, there's a couple things in here. One, that the House bills that have been added to it having had a hearing. Apparently, this language was developed last week. So I'm assuming you're aware of those things. And
Yeah.
this also affects St. Louis County.
Yes, I recognize that the bill originally did not. The two representatives and one senator has been working with some kind of a change that the change that happened would affect Kansas City also, I believe, within theirs. But they've been working with that group and contacted me and asked if it would be all right last I think it was Friday morning when things were finished.
Sure.
With that. And I'm hoping that somebody did. I knew that you contacted the office, and I wanted to believe somebody was going to come by your office and catch you up on that stuff.
They did not, but I had a conversation with one of the reps who I actually think is a really good person and I trust him.
Kind of like me,
Yeah, same with you, Mr. Chair. But, you know, as I was discussing it, still that it deals with St. Louis County, I just wanted to make sure. And but I will have to have some of those entities going to have to talk to me. I probably will vote to pass it in this committee for right now, but I think they need to, I'd like to have some conversations. And if there's any other fixes we could do to that, some of that language that we did last year, and that's what some of this is addressing, the nuisance properties and the land bank issues. I would like to get those taken care of. So,
yes,
so
as you're well
it might not be
aware,
a finished product.
this, as simple as it sounds, this is not simple. So as we continue to move through working with this bill, I'm confident that there's going to be people with good things and bad things to say. So yeah, we'll have to continue to do it.
But
and if I'm right,
just remember all mine are good things. So that's,
yeah,
that's
I
good.
think also, Cinder, I want to say this bill is fairly close to being passed in a committee, I think, on the other side as well. So it's a work in progress. Okay, we're discussing Senate Committee Sub, Senate Bill 388. Yeah. Senator Nicola.
Thank you, Mr. Chairman. I would just echo some of the sentiments from my colleague here. And there's a couple little issues I have with it as well, but I'll be a yes today, and hopefully that we can work some of those things out too. So
It's good. Thank you, Senator Nicola. Anyone else? Okay, now I've got to go back to remember where we're at. I think we're ready to accept the committee sub. We did have a second, right, Matt? So, any more discussion on the Senate committee substitute for Senate Bill 388? All those in favor of adopting the Senate committee substitute say aye. Aye. All those opposed, same sign. The substitute has been adopted. Do we have to roll? We don't. I move that we do pass Senate committee substitute, Senate Bill 388. Do I have a second? Second. I have a second. Matt, would you please call the roll?
Senators Black.
Aye.
Henderson. Aye. Beck. Aye. Bratton. Berger. Aye. Crawford. Aye. Nicola.
aye.
Nuremberg.
By your vote of 7-0, you have do pass Senate committee substitute for Senate Bill 240. Oh, yeah, 388. That's what happened when you grew up where I do. You can't read numbers. I move to bring up Senate Bill 255. Do I have a second? I have a second. Is there any discussion on Senate Bill 255? It's also noticed up last week at the end of the week. Any discussion from any of the senators? Doesn't appear we have any. I move that we do pass Senate Bill 255. Do I have a second? I have a second. Matt, would you please call the roll?
Senators Black.
Aye.
Henderson. Aye. Beck. Aye. Bratton. Berger. Aye. Crawford. Aye. Nicola.
Aye.
Nuremberg.
By your vote of 7-0, you have do pass Senate Bill 255. I move to bring up Senate Bill 396. Do I have a second? We have a second. Okay. Is there any discussion about Senate Bill 396? Seeing no discussion. Matt, would you please call the roll?
And we could do pass. You have to do pass.
Oh, yeah. Okay, I move that we do pass Senate Bill 396. Matt, would you please call the roll?
Senators Black.
Aye.
Henderson. Aye. Beck. Aye. Bratton. Berger. Aye. Crawford. Aye. Nicola.
Aye.
Nuremberg.
By your vote of 7-0, you have do pass Senate Bill 396. Okay, we've been asked to consider this bill for consent. I move that we pass Senate Bill 396 as consent. Do I have a second?
Second.
I have a second. Matt, would you please call the roll?
Senators Black,
Aye.
Henderson, Beck, Bratton, Berger, Crawford, Nicola,
Aye.
Nuremberg.
By your vote of 7-0, you have voted Senate Bill 396 as consent. I move that we leave executive session and return to the open session. Do I have a second? I have a second. All those in favor say aye. Those opposed, same sign. We are out of executive session. First bill on the agenda is going to be our House Bill 595 and 343. Representative Brown, would you please come forward? And as you're headed that way, I had supper. You people in Kansas City probably call it dinner with one of your past students Saturday night. His sister married my nephew, and this guy lied for you really well, Representative Brown. Told me how great you were, and I brought up your picture to make sure we were talking about the same person. So his last name is Hoover. He's a police officer, redhead.
I believe I know who you're talking about.
Yeah, it sounds good.
I've had a lot of kids over the years, but I still appreciate the compliment. May I go?
Please begin.
All right. Mr. Chairman, Chairman Black, committee members, thank you for the time and opportunity today to talk to you about House Bill 595. Very quickly, for the record, Chris Brown, Kansas City, District 16, the Northland of Kansas City. House Bill 595 basically is a property rights bill. In just very, very simple language, it does two things. This bill would prohibit municipal governments from creating or enforcing any sort of ordinance that would force landlords into accepting Section 8 housing vouchers. The second thing it does is it basically would again prohibit local government from creating or enforcing any ordinance that would in some way restrict landlords' ability to vet or screen tenants. Those are the kind of the two main points that this bill deals with. 595 kind of has its origin, in all honesty, to the lack of affordable housing, in particular in our large urban areas. As such, there have been several municipalities across the state, such as St. Louis City, Columbia, Clayton, Webster Grove, and most recently Kansas City, that have passed ordinance to try to help improve their housing crisis or the rental shortage they may be facing. In doing that, I submit that they have encroached on some property rights issues for land property owners. Basically, what has happened is they are forcing people to take Section 8 housing. This kind of reminds me of COVID a little bit, when there was about a year and a half there where we had an eviction moratorium where landlords could not evict tenants. I would submit this kind of amounts to an illegal appropriation of private property. But there's a very practical reason why a landlord may not want to do Section 8 housing. Section 8 housing, it's a government program. It's a voluntary government program, a bureaucratic program with a lot of bureaucratic entanglements that a landlord must be adhere to when they rent out their property. And it's just kind of my guess, I speculate on this, but a lot of people make a niche out of Section 8 housing. You know, that's kind of who they rent to. I would say that those are probably some of the larger property management folks that have the administrative staff that can kind of keep track of all the bookkeeping and the inspections and all of the just the bureaucratic things that need to be checked with a federal housing program. Also, landlords should not be limited in how they screen tenants. I've been a landlord for probably 30 plus years. When people ask me about that, you know, like, how can you do that? Don't you get tired of dealing with bad tenants, etc.? The simple truth to being a good landlord and making this work is vetting your tenants, screening your tenants. If you do that thoroughly and you get good tenants in place, it's really not that big of an issue. So for a municipal government to somehow limit how you can screen tenants, this is just absolutely, it really puts them in a very, very difficult position. And I would say this too, you know, I empathize with our urban areas and the shortage of affordable housing. I really do. But I think what ordinances like what Kansas City has put in place, what it's actually going to do, it's going to have a counter effect. Instead of getting more people in housing, what's going to happen in particular with your mom and pop landlords out there, people that own maybe 3 to 8 properties, what are they going to do? If they have all these restrictions, these bureaucratic hoops that they have to jump through, the threat of, you know, being reported to the Office of Civil Rights for some sort of civil rights violation, what they're going to do is they're going to hang it up. They're going to say, we're out, we're done, we're going to sell our property, and that's just going to take more property out of the rental market. And I want to say this before I close. I want to make sure you understand this. This is in no way an indictment against the Section 8 program at all. It's not an indictment against people that use Section 8 housing. Our simple position is we should not be forced, our property should not be forced into a federal housing program, one that we would normally, on our own volition, not enroll in. Happy to answer any questions.
Any questions? Senator Berger.
Thank you, Representative, for presenting. Can you explain how the Kansas City ordinance works or the details?
When this bill was in committee on the House side, the sponsor of the ordinance in the Kansas City Council came to kind of explain and defend it. And I sat and listened, as did everybody else on the committee, and I certainly don't want to speak to them, but I listened to it, and the ordinance, there was a lot of ambiguity to it. Basically, how it should work, and it kept coming back to one word, and that one word was solely. So in other words, if you were going to rent a property from me, I could not solely deny your claim really based on one attribute. So for example, if you had a criminal record, I couldn't say, no, I'm going to not deny you for that criminal record. We have to look at other factors as well. Or if you had a FICO sitting at 500 or below, I couldn't deny you based on that. Or if you've had an eviction in the last 12 months, I could not deny you based on that specifically. I would have to take into account other factors as well. And again, every landlord, from corporate to mom and pop like me, they probably have different ways that they evaluate tenants, right? But for the city of Kansas City or any municipality to come and say, hey, here's a certain way you have to do it. You can't just look at one particular attribute. You have to kind of look at a basket of things. I feel like it's just going a little bit too far. And as far as the Section 8 portion of it, Senator, same way. If you had a Section 8 voucher and you wanted to rent from me, I could not say to you, I'm denying your application based on Section 8. Now, if you had a criminal history, a violent criminal history, because Kansas City makes a difference between violent criminal history and nonviolent, but if you had some other attributes that I could justify denying you, that may work. But I cannot do it just based on your Section 8. And again, the Kansas City ordinance, it's punitive. I could face up to a $1,000 fine, Office of Civil Rights violation, or I could lose my permit in Kansas City to rent property in general. I mean, there's some real consequences. And again, I appreciate that councilman come to Jeff City to explain that. But again, it just seems like there's a massive gray area in how this is going to work. Not clear cut, and it just leaves too much wiggle room in there for landlords to try to figure out what's right, what's wrong, what's acceptable, and what's not. Thank you for your question, though, Senator.
Any other questions? Senator Nuremberg.
Good afternoon, Representative.
Good afternoon.
I know Councilman Duncan is here again today, so he probably will be able to provide us with some clearance as to that ordinance. But I have a question for you. Did you say that some of these ordinances have been passed in other cities as well?
Yes, that's correct. Now,
Okay.
again, in different form and fashions, but yes.
Okay, and so the Kansas City ordinance is temporarily on hold, right? There was an injunction, I think, just recently.
That is correct.
And so do you know about, on the other ordinances across the state, if those are still in place today, or have any of those been tied up in court for some of the same reasons?
That's a great question. I would assume they are still in place. Now, when the Kansas City lawsuit plays out, will that apply to them? That's something I'm not sure on.
Okay, and I say this just for the edification of the committee, just to be aware that some of this is playing out in court as we move forward, just to be really aware of that at the
Yeah.
same time as we're moving legislation one way or another. So, thank you, appreciate it.
Yep.
Any further questions? Senator Nicola.
Good afternoon, Representative. I just want to thank you as a former landlord myself in the Kansas City area. I just want to thank you for some property rights legislation here. So thank you for the work you've done on this. I appreciate it.
Absolutely.
Any further? Thank you, Representative. Okay, please raise your hand if you plan on testifying on this, either for or against. Okay, everybody put their hand down. Thank you very much for the survey. I believe we're going to start our limiting a little earlier than I thought. So for those of you that raised your hand now, start with the idea that you're going to have about 3 minutes. I'll raise the gavel whenever we get to 2.5. We're going to go through all those in favor, and then we're going to flip to those opposed, informational purposes only. Okay. First, yeah, we'll both do it. I like to be in control. So first person in favor, please come up, state your name, and we'll start.
Thank you, Mr. Chairman, members of the committee. My name is Jason Zamkus. I'm a registered lobbyist on behalf of the Missouri Association of Realtors. We'd like to go on record in support. I think the sponsor did a fantastic job of explaining the situation, but it's worth noting that the vast majority of landlords in the state of Missouri are not well-heeled corporate interests, but rather small, oftentimes mom-and-pop businesses. And we believe that they should have as much information and screening measures as necessary for them to make sound business decisions to protect not only their interest, their investment interest, but also make sure that they're ensuring the safety and security of neighboring tenants and the community at large. With that, I'd be happy to take any questions.
Any questions of this witness? Thank you, sir.
Thank you.
Next person in favor? Thank you for your witness form. Is it on?
Thank you. Thank you. Good afternoon. I support this bill, and I thank Representative Brown and Keithley for sponsoring it. My name is Stacy Johnson Cosby. I'm a Kansas City housing professional, a real estate agent of over 35 years, an investor and housing provider or landlord of almost 30 years, along with my husband, who's here with me today. And I serve as president of the KC Regional Housing Alliance. We're professional organizations, and we represent over 125,000 rental units in our region, from hundreds of small housing providers and property owners to large multi-housing owners. And I speak for all of us today. We are in business to house people, yet the Kansas City Source of Income Ordinance is driving housing providers out of our city and out of the market. When I accidentally learned about this ordinance, I immediately scheduled meetings with our council members because we know how to create more housing. If there's a shortage, we know how to create it. That's our business. But we are never invited to the table. We all know that there's a better way to house, in this particular case, Section 8 housing voucher holders. As an example, right across the state line in Kansas, they implemented a successful incentive-based voluntary program. And they ended up housing in a year and a half 500 renters, including children, which represents 176 housing units voluntarily in less than 1.5 years. We shared this information with our council members in Kansas City, Missouri, and they ignored this proven model and instead chose to penalize housing providers rather than partner with us. As a result, renters missed out on these opportunities. As you know, a federal judge has recently ruled that mandating us to accept Section 8 vouchers and entering into a separate lease with the federal government is most likely unconstitutional. But there's more left to the ordinance that still stands, as Representative Brown says. What they're doing is they're forcing private housing providers into accepting risky lease agreements. The ordinance still to this day says that we cannot deny high-risk renters without risking punishment. So we cannot confidently say no to people with an eviction over a year old, and we know that the majority of evictions, over 90% of evictions, are for non-payment of rent. We can't say no to them. We can't say no to someone with low credit scores or bad credit, or prior property damage, or criminal or arrest history. And if we do, the penalties are extreme. Yes, there's a $1,000 fine. We can also have to take a re-education class that could be up to $500. We can lose our rental permit and ability to do business in our city, and we can face jail time of up to 180 days for saying no to a high-risk renter. We surveyed 275 housing providers in early 2024, and as a direct result of Kansas City policies, we have lost and sold 873 rental units. Okay, thank you. And we're tired of being villainized, and we're willing to work with them. Oh, questions?
Oh, please, yeah. Are there any questions? Senator Beck.
Yeah, I'm curious, what is the incentive that's offered in Kansas?
In Kansas City, Kansas, and I'm sorry, it's in Johnson County, Kansas. They did a survey of the landlords and said, why don't you take the voucher and what would it take? They offered 2 months free rent as a bonus up front, and then at the back end, they cover any repairs that go beyond what the security deposit is if there's any repairs. And it's worked. They have 89 housing providers who said they otherwise would not have taken the voucher but for that incentive. And it represents about $2,400.
So they pay the landlord more money above and beyond?
Up front. They do a bonus
above and
up
beyond the
front.
rent?
I'm sorry, they give them a bonus up front of 2 months free rent, which is represented by about $2,400 plus the rent. So that's a bonus.
So they get 2 months free rent
That's
that they're getting from the taxpayers, I'm assuming?
and they in the beginning use CARES Act funding.
So
but yes,
What's that?
in the beginning they use CARES Act funding.
Which is taxpayers' money?
That's exactly right.
So they're taking taxpayer money and giving a landlord 2 more months of rent above and beyond what the applicant will pay?
That is exactly right.
Okay.
Any other questions of this witness? Thank you, ma'am. Do I have anybody else
Thank you.
testify in favor? Lay it there to your right is probably a pile.
Great.
Yeah. Please begin when you're ready.
Good afternoon. My name's Dan Kelly. I'm a landlord in Kansas City and an attorney who's been practicing landlord-tenant law in Kansas City for 30 years. I'd like to point out, well, first, as to the status of the lawsuit, I'd just like to point out that the lawsuit has a temporary injunction with regards to Section 8 program, but all of the screening criteria portion of the city ordinance are still in effect today. It's difficult for landlords to comply with this, and I'd like to point out some of the inconsistencies within the ordinance. One, Kansas City has made criminal conviction history a protected class, which means any discrimination, any refusal to rent to someone in a protected class is a violation. Later on in the ordinance, it says, well, if you've got conviction history and you can combine that with your credit history, go ahead and discriminate against that person. Or if someone has criminal history and you give them an opportunity to explain why they have a criminal history, at that point you can then go ahead and just discriminate against them. However, where does that leave the landlord? It's inconsistent, and the penalty is a $1,000 fine or 6 months in jail. It's a minimum fine of $1,000. Every applicant under the ordinance is required to receive a copy of their rights. That's every potential applicant, which means if you get a phone call and someone says, hey, is your property still available? You say yes, and they hang up, you haven't given them that. That's a violation of the ordinance. That's a $1,000 fine. The Federal Fair Housing Act requires that you treat every single individual equally. You set objective criteria, the applicant comes in, if they meet your criteria, you rent. If they don't, you don't. That way you don't discriminate. This ordinance requires you, if they don't meet your criteria, to solicit additional information and potentially rent to someone who doesn't meet your criteria, therefore making it a federal Fair Housing Act violation. So one of the complaints against this ordinance is that it would eliminate tenants with tips and VA benefits, and that is not covered under the proposed ordinance before you today, the proposed statute today. And if anyone has any questions, I can elaborate.
Do I have anyone else testify in favor?
Hi, Mr. Chairman, members of the committee, Sam Wiles, registered lobbyist, Missouri Apartment Association. Just want to go on record in support. Everybody covered pretty much everything here. I also have letters from the Apartment Association of Kansas City and Mid-Mill Apartment Association in support as well.
Thank you, Mr.
Thank you.
Wild. Any questions of this witness? Thank you. Anyone else in favor, please come forward. Right straight in front of you should be a pile. Okay, please begin when you're ready.
Good afternoon. My name is Lawrence Davis Jr. I've been a landlord for 17 years, and I'm in complete favor of this bill. I echo the sentiments of those who come before me, and I ask that you strongly consider what you've heard from each and every individual in favor of this bill.
Thank you, sir. Do we have any questions? Hold on just a moment, please. Any questions of this witness? Thank you very much. Anyone else testify in favor?
Good afternoon, Mr. Chair, members of the committee. Angie Schulte, registered lobbyist for St. Louis Apartment Association. Also want to thank Representative Brown for bringing this bill forward. I don't have anything else to add, just that we support this bill. Just to highlight a couple of other things that were already mentioned. These are folks that are in the business of housing people, and so they really want to do, like our folks are really good landlords. They're trying to get people into good housing situations, and ordinances like this just push away the smaller mom and pop companies, and also just support bringing in out-of-state buyers into Missouri. Thank you.
Any questions of this witness? Thank you. Anyone else in favor? No? Anyone in opposition? Please come forward, sir. Same thing, right? You heard the 3-minute stuff. Gavel means you're 2:30. Please begin when you're ready. Witness form, very good.
Good afternoon, Mr. Chair, Mr. Black, members of the committee. My name is Jonathan Duncan. I serve as City Council representative in the City of Kansas City. I'm also a combat veteran. The reason I bring that up is because when I ran for office, I wanted to ensure that veterans had a voice on City Council. Somebody brought up earlier in advocating for this bill that the bill in front of you doesn't hurt veterans, and that just couldn't be further from the truth. Part of the ordinance in Kansas City that I sponsored ensured that if you have veteran disability benefits, that those benefits count as a legitimate form of income. I've spoken with veterans who have been denied by landlords because the landlord can't garnish the wages of your disability benefits, and so those benefits weren't counted as legitimate forms of income, preventing that veteran from being able to be sustained and housed. What this ordinance does is it just makes it a little bit easier for people to find housing in Kansas City, which Kansas City is no different than the rest of the nation. It's currently in a housing crisis. In fact, we have 47,000 units of deeply affordable housing deficit in the city of Kansas City. Now, while we are producing more affordable housing units, and we are trying to preserve the affordable housing units that we do have, tenant protections is a part of that as well. And so that's exactly what this ordinance aimed to do. Now, a lot of people brought up that you can't screen your tenants, which couldn't be further from the truth. There are some factual inaccuracies of the testimony before. This ordinance does not force you to rent to anyone. All it simply states is that you can't solely discriminate against somebody because they have a Section 8 voucher, Or you can't solely discriminate against somebody because they pay the rent with Social Security benefits or with veterans disability benefits, or that a portion of your rent that is being paid with you're a single mother and you're receiving some type of alimony or child support. That can't be a legitimate claim to simply say, we're not going to rent to you here. You have to factor in the complete applicant, which means that, as somebody said before, that yes, if you are a violent criminal, then you can be denied your application. If you have a low credit score and you have a past criminal history or a past eviction, you can be denied housing. I also want to bring up the fact that we did meet with Stacy Johnson Cosby and other landlords, and we incorporated that same landlord mitigation fund, $1 million, into this ordinance in conversation with landlords who said, hey, if we comply with this, we're going to need some assistance. We're going to need some help. So we made a series of amendments that I've passed to Senator Nuremberg, and I'd be happy to pass to everyone else, about the amendments that went through the months and months of crafting this ordinance. I will end by just simply stating that this ordinance does not force anybody to do anything. It just simply makes you consider the entire applicant when renting in Kansas City.
Thank you, sir. Any questions of this witness? Senator Harrison.
I have we talked about the solely part. So if I have a vast criminal history, say I do, but I've got some money, I've got the thing, would this, when we talk about solely, would this keep them from renting to me, or could they this ordinance prevent them from denying me, even though I have a violent criminal history? I meet the other things. I've got a good credit score, I've got everything, but maybe there's a lot of kids that live in this area right here. So could that be the sole reason?
So if you have a violent criminal history or some type of sexual criminal history, that is an exception, right? We're talking about a criminal history like if you stole a loaf of bread, or you didn't pay some parking fines, you have a municipal ordinance violation. That can't be a reason to solely discriminate against somebody for housing. But if you have a violent criminal history, and I have the ordinance here.
So it's laid out in the ordinance that that could be the sole reason, the only
Correct.
reason.
Absolutely.
Okay.
Senator Beck.
Thanks for coming here today. I'm going to have a question that's kind of related to this bill or kind of related to your ordinance. And the Senator Nicola here and myself filed some legislation that would restrict foreign corporations, meaning, corporations outside of the state, from buying up what we used to consider as starter housing. And a lot of that's going on, and that's probably going on quite a bit in Kansas City. And the trouble with that is they buy these properties, then they turn them into rental, and then they drive the neighborhood values down because they're absent landlords. Do you see a lot of this going on within your city? I mean, we're trying to address these issues, and I understand what this is trying to do, but also, do you see that as a problem?
We definitely do. In fact, I think it was something on the lines of 30% of the single-family homes that were purchased over the last couple of years were purchased by out-of-state companies, venture capitalists.
Yeah, and some of them for just the taxes owed and things of that nature. They buy them in the courthouse steps. So I'm just curious if this language goes further, and I know you're probably opposed to this language, but something like that would be something that could be possibly amended on this bill.
Well, so for this ordinance, this is only for renters. So we actually carved out an exception in conversations with people who didn't support the first draft. We carved out an exception for real estate property. So this wouldn't affect people who are purchasing homes.
Okay. No, I was talking about this currently the legislation in front of us. That if I added this to it, it might be a relief, and if there's some changes to the wording here or something of that nature. So I was just curious. But never mind. It's not a question. It's for my own self.
Any other questions? Senator Nuremberg.
Good afternoon. Thanks for joining us here in Jeff City today. And so I believe, and I know this legislation, I think it was around last year. I could have asked the sponsor that. But as we look at this and consider this now in the Senate, would you help me or help the committee with some any sort of background that you have on ordinances like this, ban on income, source of income discrimination that have been passed in other cities and states? And if you're aware of, I believe that this has been done in other areas, other parts of the nation, and then when they were passed and if some of those things have been litigated, One of the things that I'm looking at, and we do this a lot in the legislature, as things are moving and everything's very fluid, just having a better understanding of what's already been litigated in other states so we don't run into the same problems.
Yeah, absolutely. Councilor Gabriel Shriver, who is the mayor's chief counsel, will be able to provide some more legal analysis.
Okay.
But this policy, this source of income discrimination ban, was actually based off 120 other municipality similar policies across the United States. We know that there are some other similar legislation in Missouri. Some of them have faced legal scrutiny and they've won. Currently, as you know, there's a federal preliminary injunction against this, and the preliminary injunction is solely focused on that Section 8 voucher piece. And so with this preemption, with this preemption bill, given the federal injunction, the preemption bill now is solely focused on removing the protections for veterans and seniors. That piece that I talked about before, that regardless of how you pay your rent, whether it be for your veteran disability benefits or for your Social Security, your SSDI, that all of those protections now will be removed if HB595 is passed. What was your question regarding other municipalities?
Yeah, just in other states that this has been passed and when some of those went into effect, if those have been.
So,
and again, I know you provided me some information. I haven't even been able to peruse it all.
okay.
But if I think it's helpful if you send that on to the rest of the committee too.
Yeah,
so we have
120 cities and 20 states nationwide have similar source of income discrimination bans. Example of these bans include Colorado, Illinois, Oklahoma, Utah, and Virginia. The cities of Phoenix, Arizona, Lawrence, Kansas, Minneapolis, Minnesota, Columbus, Ohio, St. Louis, Missouri, and Webster Groves, Missouri have similar bans. I also want to speak to the fact that what is different is the escalation in this ban, right? So the first form of, if you are a landlord who's found to have violated this ordinance, you're contacted and say, hey, you're in violation, will you fix the violation? If the answer is yes, then that's over. But if the answer is no, I don't believe, then it goes to a further investigation. And if you refuse to comply, if you're found to be in violation, then that's when you can be cited. That's when a fine can be assessed against you, but only after the basis of this ordinance is not to hurt landlords. The basis of this ordinance is to provide more housing. So we just want compliance with the ordinance. So these scare tactics of saying that you can be put in jail, that's only if you ignore every notice and every ability to actually correct the violation that you were found to be in.
Thank you.
Any further questions of the witness? Yes, Senator Nicole.
Thank you, sir. Did you say you sit on the Kansas City Council, is that right? City
Yes,
Council?
I'm a council member for the 6th District of City, Kansas City.
6th District, thank you. And tell me your name again.
Jonathan Duncan.
Thank you, Congressman, or Councilman, I appreciate it very much.
Don't
Thanks.
promote me.
Senator Henderson.
One more quick question. So you're saying on the first offense, your policy clearly states they can't be fined on the first offense at all?
Correct. The first step would be you'd be contacted as a landlord.
But it says in there, does it say they can, or are you saying they normally don't?
They won't.
So they can't?
They cannot. They will not be fined on the first offense. It's repeated offenses and ignoring the policy.
Okay.
So it's an escalation. It's not your first time, then you're slapped. No.
Thank you, sir. Anyone else to testify opposing? Yes, please come forward. You should have a witness form. If you don't, they're sitting to the right. Just fill it out and leave it. And please begin when you're ready.
Hi, thank you, Chairman Black and committee members. My name is Misha Smith. I am with Empower Missouri, and I am an affordable housing policy manager. We are Missouri's oldest organization, anti-poverty organization in the state, and part of my work is convening a statewide affordable housing coalition where we bring people from all different parts of housing work, advocacy together to discuss issues. And we are asking, as part of our board, our organization, and our coalition, we ask the committee members to please vote no on this bill, HB595. Our primary concern is that it would increased lack of access to affordable housing. I know I've heard it mentioned a lot that these SOI discrimination bans are actually creating more gaps in housing. However, I will be willing to send this information on, but the data shows that in areas with these discrimination bans in place, people are actually housed quicker and they stay longer. And also, as we know, we hear it all the time, housing is the solution to ending homelessness. The Housing and Urban HUD stated last year when they did their PIT count, they released it this year, that homelessness increased 18%. Family homelessness, which is a household with a child in it, increased 40%. In Missouri, homelessness among families with at least one child under 18 who are unsheltered went up 52%. This is relevant because the biggest recipient of vouchers in our state are children. The second are older Americans, who also saw a 42% increase in unsheltered homelessness. And this is also tied to the fact that once a person gets a voucher, only 1 in 4 people eligible due to underfunding are even able to access a voucher. And then in areas, 67% of municipalities, landlords in these areas are refusing to rent to people with vouchers. And so we are seeing homelessness increase in these areas where people are struggling to access housing because they are being denied based on having a voucher. And so we ask you to vote no. Any questions?
Any questions of this witness? Seeing none, thank you very much.
Thank you.
Yeah. Ask the group, if you see me do the 30-second sign and you're opposed, could you stand up and be ready to go our next time through? So please come forward, state your name, we'll begin.
Mr. Chairman, members of the committee, Zach Pollock, registered lobbyist for the Missouri Housing Authority Association. I just want to go on record in opposition to this bill. I think the previous witness pretty much covered our opposition.
Okay, thank you, sir. Any questions of this witness? I see none. Thank you. Anyone else in opposition? Please lay your witness form down, or if you don't have one, pick up one of the blank ones and bring it back up. Okay, please begin when you're ready.
Thank you, Senators, for your civil service. My name is Dave Bennett, and I'm currently a student at UMKC in their Department of Social Work, serving in a practicum with unhoused people at a housing organization in Kansas City. And we assist people who are elderly and chronically ill and those with disabilities. The individuals with whom I work have each struggled with homelessness in the past, and due to their conditions, they've qualified for housing vouchers to allow them to pay rents in Kansas City. Like a few other municipalities in Kansas City, or in Missouri, Kansas City has passed an ordinance, as you've heard about, that has widespread community support that would prevent discrimination against clients like mine, or people like mine, my clients, based upon the fact that they have a housing voucher. And without such an ordinance, a person with a disability would effectively be legally allowed to face housing discrimination. And as Senator Nuremberg was asking earlier, kind of the impacts of laws like 585 or 595 passing, that would mean more homelessness in cities. We would see more people unhoused. And it doesn't seem like I see any wording in the bills that address this issue. Seems like that's unaddressed by 595 and similar bills. The people of Kansas City, Columbia, St. Louis, and other communities, they know what works to meet the housing needs of their neighbors. And although there are some landowners who are concerned about being fined, we understand that. But there's also people who face being without a house. And these are people with disabilities, elderly people, like was already said, children. So the policy takes away local control in addition to all this and diminishes the rights of people to find housing, provides no reasoned alternative to support people in our communities with special needs. I'm happy to accept questions from the committee.
Are there any questions of this witness? I don't see any, sir. Thank you very much. Is there
Thank you.
anyone else testifying opposition of House Bill 595 and 343? Just lay your witness form up there in front. Sit down. Please state your name and begin.
Hello.
Hello.
My name is Robbie Banez. I am a tenant from Springfield, Missouri within Greene County. Before I go any further, I just want to share a couple of things about the city of Springfield before my expression on opposition to HB 595. Springfield is a slumlord city with 60% of our residents being working class tenants, including their families. Our poverty rate is at 18 to 19%, when the national rate is at 11 to 12%, and our state poverty rate is at 13%. Springfield is often considered to be the poorest city in the state of Missouri, and it shows. We are also currently experiencing a housing shortage. We lack roughly 9,000 affordable rental units to keep up with our housing needs. A full-time minimum wage earner would have to work 58 hours a week to afford the average rent for a two-bedroom apartment in Springfield. That's around $1,100 without utilities, and it doesn't necessarily help that our state has been under a rent control ban as of August 28th, 1989. Title 29, Chapter 441, Section 03, or 43, but I digress. This bill and other similar bills to this is just overreach on allowing local governments to make decisions that will meet the needs of their communities. So I just ask that y'all consider voting no on this bill. Just like everyone else that's been opposing it, it just creates more barriers and struggles for working class families to find housing, especially with like communities like in Springfield. But that's all I really wanted to just share.
Thank you, sir. Any questions of this witness? Seeing none, thank you very much.
Thank you.
Is there anyone else to testify in opposition? We do have one more. Please come forward. Witness form lay there on the desk. Please begin.
Mr. Chairman, members of the committee, thank you for having me. My name is Gabriel Schreiber. I am general counsel to the mayor of Kansas City, and I played a significant role in drafting the Kansas City ordinance that we've heard so much about. I want to be clear that the bill that you have before you now does something different than when it was introduced. Given the recent court order, this bill no longer deals with Section 8 housing vouchers. Instead, it targets some of our most respected citizens, veterans, seniors. There are veterans in Kansas City who get most of their income from veterans benefits, but cannot pay for rent because they're excluded because their benefits don't count towards their rent-to-income ratio that landlords mandate. There are seniors in the same position with regards to their Social Security benefits. The bill before you now, given the injunction in the court, deals only with those people and would prevent cities from banning discrimination against veterans, seniors, and other non-Section 8 voucher holders who have non-traditional forms of income. As originally written, the Kansas City ordinance would also deal with housing vouchers. The ordinance says at its base that if you have a lawful source of income, a landlord cannot refuse to rent to you simply because they don't like where you get your lawful money from. Because of this, Kansas City took the non-radical step of joining many jurisdictions, including conservative jurisdictions like Oklahoma, like North Dakota, like Utah, other jurisdictions across Missouri like Webster Groves and Clayton, in prohibiting discrimination based on a renter's lawful source of income. We did this with significant thought and significant collaboration. There were months and months of negotiations with many landlords and landlord groups, and a huge number of last-minute changes. Senator Nirenberg has and will circulate a list of some of the last-minute changes. One of the notable outcomes of a last-minute change is a $1 million fund for landlords to help them ease any administrative burdens they might have in accepting individuals with non-traditional sources of income. That $1 million fund is a pilot program, and there are discussions about renewing it should it be drawn down by landlords and necessary in Kansas City. I urge opposition to this bill so that you allow Kansas City to preserve protections for veterans, for seniors, for families, and allow the city to enforce or at least see how the compromise that we've reached through significant compromise and discussion with a whole broad cross-section of our community actually works in practice. With that, I'm open to questions.
Thank you, sir. Any questions of this witness? I see none. Thank you very much for your time. Do I have anyone else to testify in opposition? Anyone to testify informational purposes only? Representative Brown, any closing comments you'd like to bring before the Senate committee?
None right now.
Thank you very much. This concludes the hearing on House Bill 595 and 343. So anybody that wants to exit this time, we'll take just a second to do that. Okay, here pretty quick, we're going to begin on the Senate joint resolutions. As it was noticed up, some of you, I want to say many of you knew what the plan was. I stated the plan before we began committee. We will go through a presentation from each one of the four senators, beginning with Senator Moon here in a moment. And then again, our witness testimony when we get to that point will be timed at 3 minutes. People in the audience, I will go out to present a bill after a while. That doesn't mean I'm mad at anybody, but I will probably need to do that before we're done. Senator Moon, I think I've taken care of the housekeeping stuff, so if you want to, please begin.
Mr. Chairman, I think you have some housekeeping to do here, but I'll take care of that in the meantime. Thank you, Mr. Chairman and committee. My name is Mike Moon. I represent the Missouri 29th Senatorial District and I'm here to present Senate Joint Resolution number 10. Some of you may have read the book Animal Farm, and if you have, you may remember Squealer the pig. And he mentioned in that book that all pigs are equal, just some pigs are more equal than others. And I think we can put some everyday examples on that, like if you're a golfer, which I'm not a very good one, or a bowler, again, which I'm not a very good one. There are handicaps that are issued for those who might not be as adept as others. That brings to my mind the Electoral College. When you consider what the brilliance of our founding fathers and what they did to bring all the states more on a level playing field, I think Virginia was probably the biggest state in the colonies at the time. Today we have California, Texas, Florida, New York, Pennsylvania, Illinois. Those states probably could get together with maybe a few others and determine who the president might be. But because of the brilliance of the founders, they put together a plan that would allow them not to be the drivers and the sole predictors and electors of the President of the United States. So they developed the Electoral College, where all the states are put on a more concurrent level so that they can all have a part in that decision. In Missouri, we have kind of a similar disparity, if you're looking at it from the state level, now we bring it down to, or the national level, now bring it down to the state level, where we have Kansas City, St. Louis, Springfield, the three major cities, and their populations can, much in amongst themselves, drive elections and what might lose or win in those support levels. I found that about 55% of Missouri's population lives in metropolitan St. Louis and Kansas City. So Senate Joint Resolution 10 would require any constitutional amendment or new constitution to be approved by both a simple majority of the votes cast on the measure statewide and a simple majority of the votes cast in a majority of the state representative districts. So in addition to that, too, no person shall be able to vote on any measure submitted to the people that amends, repeals, or replaces the Constitution, whether submitted through the initiative petition process by the General Assembly or by a constitutional convention, unless the person is a legal resident of the state of Missouri and that person is also a citizen of the United States. So back to the electoral college model. If we used Missouri House districts, for example, there are 163 House districts, to pass a measure, you would not only have to have a simple majority, 50% plus one, but also a concurrent majority of at least 82 House districts. And so not only would populous cities continue to have their voices heard, but rural and suburban areas would also be provided an equal playing field by a concurrent majority. Voters in my district, the 29th Senatorial District, believe their voices are muted. And so a current majority would allow, as modeled in Senate Joint Resolution 10, their voices to be heard again. And so I think that in itself is, at least in my opinion, a fair representation of Senate Joint Resolution 10. And if there are questions, I'd be happy to answer. Are you going to hear them all and take questions later? Mr. Chairman?
Well, if anybody has any questions of you right now, Senator Moon, fine. But when we conclude with Senator Bean, if there's any questions of all senators, we will do that. But if you have to take off, we understand. Does anybody have any questions, Senator Moon, at this point? Yes, Senator.
Good afternoon, Senator.
Good afternoon.
I sure like it when we're on the same page, but here we go again with something that obviously...
Which page are you on, Senator?
Well, I was going to say, let's go back to utilities, and we could probably have a lot more in
let's go back there.
But here we are on SJR10, and you're leading with ballot candy that essentially requires residency and citizenship to be able to vote. And didn't we just do that with Amendment 7 that we passed in last fall?
Yes, and I also think that, you know, there are illegal residents in Missouri who could present themselves as residents, and so this would just be affirming that.
But Amendment 7 literally led with, make the Constitution consistent with the state law by only allowing citizens of the United States to vote. And so right here, this is duplicative of what we already have in our Constitution.
And if that needs to be removed, I'm okay with that.
Okay. I would like us at least to lead with what folks are actually voting on. Okay.
Sure.
Thank you, Senator.
You're welcome.
Any other questions? Senator Beck?
Does this only apply to IPs? Does this only apply to IPs, initiative petitions?
Yes. I think that, let me look back in here again. Constitutional amendment or new constitution.
So an SJR, HJR would not apply to that?
Right.
Senator Henderson?
I wanted to say thank you for bringing this. I'm probably going to say it to all of them that are bringing forward. So I think it's a real issue. I think you hit on one of the issues for me. I've carried this bill in years past. And one of the issues with me is it kind of becomes a rural versus urban. I think you're correct on that, in that it seems like a lot of people in my area get frustrated and feel like it doesn't matter how we vote because we get outvoted by the metropolitan area. So I do think that there's a little bit to the rural versus urban divide. We talk about different divides up here, you know, political parties and different things and different ideologies, but I think sometimes it's a rural versus urban. Thank you.
You're welcome.
Thank you, Senator Moon.
You're welcome.
Okay, Senator Brown, You are next on my list, and Senator Carter. Please begin, Senator Brown, when you're ready.
Thank you. For the record, my name is Senator Ben Brown of the 26th District, and I'd like to thank the committee for the opportunity to present SJR30. If approved by the voters, this resolution would reform the initiative petition process in our state. We want to maintain the access to the ballot for citizens while also ensuring that the initiative petition process is truly being utilized to advance the interests of Missourians and not that of well-funded out-of-state special interest groups. In order to prevent this, we must ensure that amendments to our Constitution are representative of Missouri values and not simply being purchased by groups funneling money into a couple large population centers. Instead of requiring a simple statewide majority, constitutional amendments would have to be approved by more than 50% of voters and a majority of House districts, ensuring that the interests of Missourians throughout the state are represented in this process. This would put the process more in line with the Republican system of government that our country was founded upon, as well as with what is required at the federal level. Though under this resolution, the threshold would still remain 50%, much lower than the 75% of states required to amend the U.S. Constitution. This resolution also contains provision that would ban foreign contributions to ballot initiatives. This provision is similar to what was laid out when I presented Senate Bill 152 the other week, which has already been passed out of this committee as a standalone bill. As I stated in that hearing, out of all the states that foreign money is pouring into to influence elections, Missouri ranks number 3 with several $1 million being spent in the last election cycle alone. I think that Senator Moon did a great job of explaining the importance of this. So with that being said, I am happy to take any questions.
Senator Nuremberg.
Thank you. Hi, Senator.
Hey.
I'm still waiting for a hearing where we don't have to hear one of your bills, but here we go again.
One of these days.
Okay, you have something different in your SJR with the public comment requirement.
Is that in the sub that was distributed?
Oh, maybe it's not. I'm looking at. Is it still in the sub?
I don't believe it is. Yeah, if you look on the summary page of the sub, the fourth bullet point there.
You got rid of that piece?
Yes.
Okay. And then I'm going to go back to, isn't it already illegal for foreign money to be accepted for ballot measures?
It is not. It was until I believe it was a Supreme Court ruling in 1995, the result of which was under federal law. Let me take a step back. And under federal law, there is a prohibition of foreign funding of quote-unquote elections, but due to that ruling, the term elections was deemed to mean candidates, and it wasn't applicable to ballot measures in that opinion that was issued. So since then, that's when you've seen just this inflow of millions upon millions of dollars aimed at influencing the process to amend state constitutions. As I stated in the hearing for 152, I believe his name is Hans-Georg Wyss, has contributed nearly $300 million to groups like the 1630 Fund that then turn around and invest millions of dollars in these state elections to amend our constitutions.
Okay, so one of the, and I think I'm looking at your original SJR, so I'm sorry if I have the line number incorrect, but essentially here you have, you're delineating that the contribution cannot go to a political committee or political party favoring or opposing an amendment. So why not just make it very clear here that it can't go to any political party, amendment, resolution, or candidate, period? Let's get foreign money out of elections altogether.
Yeah, I think that might be kind of duplicative of what's already federal law, but I wouldn't have an issue elaborating on that in the
Okay.
resolution as
Thank
well.
you.
Any further questions of Senator? Thank you, Senator Brown. Senator Carter.
Thank you, committee members. Senator Jill Carter, representing the 32nd District. This is SJR47. It's very similar to the proposed amendments that legislation that we've just heard from Senator Moon and from Senator Brown. More identically aligned with Senator Brown's language. If you need me to explain any more, I'm happy to do that, but just for sake of time, turn it over to questions if you have any.
Does Senator have any questions of Senator Carter? Thank you, Senator Carter.
All right, thank you.
Senator Bean.
Mr. Chairman, members, committee, for the record, Senator Jason Bean, representing the 25th District, here to present for your consideration Senate Joint Resolution Number 11. It's been a priority of the majority party over the last few years to get initiative petition reform across the finish line, but we've been unsuccessful so far. Many previous efforts focused on the ratification process and increasing the threshold for approval. I've decided to take a different approach so we can have a conversation about the steps to put a petition on the ballot. Currently, the Missouri Constitution requires the initiative petition seeking to amend the Constitution to gather signatures and 8% of the legal voters in each of the 2/3 of the congressional districts. Initiative petition seeking to propose laws to gather signatures equal to 5% of the legal voters in 2 out of the 3 congressional districts. If Senate Joint Resolution 11 was approved, initiative petitions proposing constitutional amendments to gather signatures would be equal to 15% of the legal voters in all of congressional districts. Initiative petitions proposing laws to gather signatures equal to 10% of the legal voters in all congressional districts. I want to see rural Missouri have more to say in what it makes into going onto the ballot. So signatures only have to be gathered in 6 out of the 8 congressional districts. It's usually my congressional district, the 8th, and your district, Mr. Chairman, number 6, that special interest groups and initiative petition sponsors don't visit to collect signatures. I think it's fair that signatures should be collected in all congressional districts. Our state constitution is a sacred document, and in order to amendment, efforts to do so should have a strong support across all of Missouri. Increasing the percentage of signatures to gather ensures the initiative petition has more support to make it on the ballot. The other piece of SJR adds a provision about the approval process. The amendment stipulates that the initiative petition still must receive a simple majority, but additionally, the total number of votes in support cannot be less than 35% of the total number of ballots cast in the election. This component is in Nebraska and targets a low turnout election. If the turnout is very low, we still want to see at least 35% of those voted in the election to have supported or voted on amendment or proposition for passage. I look forward to working with the committee and my fellow senators who have sponsored resolutions to address this important issue and work toward the consensus on a resolution that we can bring to the Senate floor. With that, I'd be glad to take any questions.
Senator Henderson.
Senator Bean, how many times do you think they've ever gathered signatures in yours and mine? Because I'm also in the 8th in our district.
I can't think of a time, so.
I've actually looked it up one time, and I've never been found a record where they ever even came down there.
No, very, very frustrating.
And so I hear from my constituents sometimes that they're very frustrated. They don't even think they're a part of the process, and it doesn't really matter. But thank you for bringing this.
Anybody? Senator Nurnberg.
Good afternoon, Senator.
Good afternoon. How are you?
I'm doing just fine. I think you probably win the prize here for the resolution with probably the most impossible threshold to pass. Are you aware of any of the initiative petitions that have passed with that 35% of the total ballots cast?
I'm not. I'd have to look into that and see. Like I say, that we patterned that off of Nebraska. So.
Okay. And I'm not aware either. That is an almost impossible threshold. And again, I think it would lead to a large delay in tallying total votes to see if something had passed or not. But that's a difficult one for sure. Okay. Maybe some of our witnesses can speak to that. Thank you, Senator.
Any other questions of the senator? Seeing none, Senator. All four senators. I said at the end of this, I would ask anybody on the committee, do you have a question of any of the four now? Senator Nicola?
I don't have any question, but I would like to, Mr. Chairman, just make a comment. I just want to thank all the senators for working really hard on this. I like a lot of provisions in all of these bills, and I think we need better representation, more fair representation across the state. So I just want to thank you very much for your hard work on this issue.
Thank you. Okay, housekeeping. We're going to go anybody in favor first, anybody opposed second, etc. I think maybe some of you that have been sitting in here for a while figured out that the House bill from Representative Brown took a little longer than I would thought was going to happen. So with that, we're going to make a time adjustment. So start going through your speeches. We're going to do 2 minutes. I will put up the gavel, or Senator Henderson may take my place here in a minute, at 1:30. That's giving you that 30 seconds warning. With that, first person in favor, I'm going to be adjusting my time. You come forward. Thank you, Sam. Please lay your witness form and begin.
Thank you, Mr. Chairman, members of the committee. Samuel Lee with Campaign Life Missouri to go on record in support of all four proposals that are before you. I've got one witness form that has all four joint resolutions on there. In terms of economy of time, I want to draw the committee's attention to the urgency to pass something this year and no later than next year. And that is because there is an initiative petition, actually 8 versions of an initiative petition that has been filed with the Secretary of State by a group so-called Respect Voters Coalition. And that would literally, if that were to become law in the Constitution, would prohibit all 4 of those measures from even being passed by the General Assembly. In addition, it would prohibit the proposal by Senator Brown that prohibits foreign funding of campaigns. It does so by prohibiting the legislature from, quote unquote, weakening citizens' direct lawmaking power, and provides for extremely broad language. If someone wants to question me, I'm happy to read that, but I'm appreciative of the 2 minutes time. It would also say that if any measure in the past, or when this proposal be voted on, or in the future, were to be changed by the General Assembly, any citizen initiated, it would take 80% of both bodies of the General Assembly to change that. So doing the math, that means to change anything from 1910 to the present day and in the future, it would take 28 senators and 131 House members to change, to send it to a vote of the people for them to consider changing it. I'm happy to stop here. There's a lot of people who want to testify, but this is something that requires much urgency, and I would hope that the committee would consider putting something out. I would just say also, since this proposal is for both initiatives for amendments and laws, that to amend Article 3 is the better way to go than amending Article 12 of the Missouri Constitution.
Thank you. Any questions of this witness? Being none. Thank you very much.
Thank you.
Next person in favor, please come forward. Leave your witness.
Mr. Chairman, may I pass out?
Yes, quickly, please.
I'm happy to go this late in the process, Mr. Chairman, because I haven't seen you throw that gavel once. It makes me feel more comfortable. For the record, my name is Ron Calzone. I'm one of the directors of Missouri First, and although I like elements in all 4 of the SJRs that have been presented, I'm here particularly to testify in support of SJR10 and 47. And I'd like to point out, let me just start with this handout. If you go to the centerfold of the handout, you'll see what's required in each of the 50 states for both ratifying amendments to their constitution and also for the legislature proposing amendments to the Constitution. So the right-hand column in pages 6 and 7 show what legislative action is necessary to propose an amendment. And what you'll see is 72% of the states require some supermajority vote of the legislature just to propose an amendment, just to put it on the ballot. And I say that to make this very important point about what I think is an essential element in whatever we do for ratification reform. That is to make sure that it applies the higher bar, which we need. The higher bar applies to any proposed amendment, whether it's proposed by the legislature, the initiative petition process, or if it's proposed by a constitutional convention. It needs to, contrary to what my friend just testified, it needs to be in Article 12 if you want to also protect against amendments through the constitutional convention process. So to echo what Senator Moon said, maybe elaborate on a little bit more, the concurrent majority principle in SJR 10 and 47 is how we pass every law. That's how we amend the U.S. Constitution, that's how we elect the president, and every single bill that goes through this process is passed by concurrent majority because you all represent different geographic parts of the state. And you probably heard all that you need to hear. I'm open for questions.
Thank you, Mr. Calzone. Any questions to the witness? Thank you very much. Anyone else testify in favor of the Senate joint resolutions presented to us today? You state your name and begin.
Good morning, Mr. Chairman, or afternoon. Good afternoon, Mr. Chairman, members of the committee. Mark Figgenbaum with Missouri Farm Bureau, testifying in favor of all four bills. We have long-standing policy of supporting increasing guardrails to our Constitution in the amendment process. With preference to concurrent majorities, we also have language or policy supporting the signature gathering in each congressional district. And with that, I'd be happy to take any questions.
Thank you, sir. Any questions of this witness? Don't see any. Thank you very much. Anyone else to testify in favor of the Senate joint resolutions, please? They need slides on them, don't they? Please begin, sir, when you're ready.
Good afternoon. My name is Dave Robertson from Jefferson County. I'm speaking in support of SJR30. I have followed the initiative petition IP process the last few election cycles and have been involved in grassroots politics for 10 years. I've become convinced IP in its current form is being used to hijack our state constitution and corrupt Missouri. The federal constitution requires 2/3 of both houses of Congress and 3/4 of the states to ratify the constitution. The founders made it difficult to amend the federal constitution with good reason, since it's the foundation of our system of government. In contrast, Missouri requires a simple 50% plus one vote to amend our state constitution. Currently, the initiative petition process is being abused as a vehicle to circumvent supermajorities in the House and Senate and to further an agenda that is at odds with the vast majority of our legislature and most people of this state. Groups outside Missouri and outside the country are pumping in millions of dollars to, one, pay people from outside Missouri to collect signatures to get an initiative on the ballot. Number two, word the initiative petition in a dishonest and manipulative way to hide the true intent of the petition and trick citizens into voting for something they don't fully understand. For example, using wording like establishes a constitutional right to make decisions about reproductive health care when it really means the right to get rid of babies. Number three, pump millions of dollars into advertising blitz to lie to the voters about the nature of the petition. In the last few years, the initiative petition process has given our state legalization of marijuana, full-term abortion on demand, transgender surgeries for minors, and so on. Some will say this is democracy, allowing the people to vote by a simple majority. However, we are not a democracy, we're a constitutional republic, and that's the citizens vote. Citizens do not vote on the laws, they vote for representatives who vote in the laws. So I think the IP process now, as it stands, violates this principle of Republican government. Thank you.
Thank you, sir. Hold on just a moment. Any questions of this witness? See, thank you very much, sir.
Thank you.
Anyone else in favor Please come forward. State your name and begin.
Chairman Black, members of the committee, my name is Bev Aylen. I'm going on record for Liberty Link, Missouri, or Warren County Republican Committee, and even the Republican Association for Central Committees. We are in support of making it more difficult to, so we're in support of 10, 30, and 47, making it more difficult to ratify, to change our Constitution by adding an amendment. However, we are stuck with the Citizens Initiative petition process, as the previous witness said, that we are a Republican form of government. Our U.S. Constitution guaranteed that. However, our Citizens Initiative petition process makes it a direct democracy. We're not opposed to making it more, like in Senator Bean's SJR, to have it more representation, but the more signatures makes it difficult for true citizens to actually get something on the ballot. So we're not trying to make it more difficult to get on the ballot, because the special interests would just have to pay more money. True citizens would have to work harder. So we are opposed to making it harder to get on the ballot, but not opposed to making it across the state, just like the Electoral College approach to the making the amendments to the Constitution.
Thank you. Any questions of this witness? And thank you very much. Anyone else to testify in favor of the joint resolutions? Please state your name and begin.
Lisa Panett with Armorvine, and we just want to voice our support for SJR10, 47, and 30. That's all.
Thank you. Anyone else, or any questions? Excuse me, ma'am. Any questions? Thank you very much. Anyone else to testify in favor of the joint resolutions? Okay, last time. We're going to begin opposition. First one testify in opposition of the Senate joint resolutions. Please state your name and begin.
Thank you, Mr. Chair, members of the committee. My name's Denise Lieberman. I'm the Director and General Counsel of the Missouri Voter Protection Coalition. We're a nonpartisan state table of voter advocates who work to ensure that voting is free, fair, and accessible to all Missourians. We are testifying today in opposition to all 4 SJRs. At the beginning of this hearing, Senator Moon talked about the importance of fairness, and I would suggest to you that's exactly what we need to speak about today. The various concurrent majority thresholds offered by these bills would create an unfair system in which some votes weigh more than others. Indeed, votes from smaller districts would carry greater weight than votes from larger districts under those provisions. Missouri's more than century-long citizen initiative process has a proud history of allowing citizens to engage from all spectrums of the political spectrum, from conservative to liberal to everything in between. But the thing that has marked the success of our century-long citizen initiative process is the majority rules. And that's how we elect representatives to sit in this body. That is how we vote on things that citizens care about. These measures are particularly important to allow citizens to raise issues themselves. If we want a more engaged electorate, an electorate that is encouraged to discuss issues with one another, we need to maintain Missouri's citizen initiative process intact. Finally, I will state that there is a lot of ballot candy in these proposals, from the citizenship language to the language banning foreign funding. Missouri's Constitution does already explicitly ban any campaign committees, as well as campaigns and political parties, from knowingly accepting any contributions from non-U.S. agents, foreign governments, or others.
Thank you. Any questions of this witness? Yes, Senator Nuremberg.
Hi, Denise. Thank you for being here. Obviously, especially last year and the year before, we talked a lot about one person, one vote, and how this gives a disproportionate share of the vote to certain folks, where my vote in the 5th congressional district simply would not count as much as somebody's vote, same one person's vote in the 8th congressional district, for example.
Right.
But one of the things that, so obviously I have grave concerns about concurrent majority, but one of the things that in Senator Bean's resolution is that threshold to pass at least 35% of total ballots cast in the election. Would you speak a little bit to how problematic that could be and how that could differ based on what type of an election it is, whether it's a presidential election during a presidential year versus a special election that's called in June?
Certainly. The provisions in SJR11 impose a passage threshold that would be, frankly, impossible to manage, right, by requiring not just a majority of votes cast on the measure, but also at least 35% of the total ballots cast in an entire election. We know that many people, it's not uncommon for people to undervote down ballot races, especially in very big elections like, say, president and Senate and federal races.
Yeah, I think back to the 2024 ballot and how long that was. We had a lot of undervoting.
Exactly. And so you can have a situation with those undervotes, especially in large elections, where a measure wouldn't pass even if 100% of the voters voted in favor of it, if they didn't represent 35% of the people that actually came out in that election. The results of one matter should not depend on the number of people who come out for another matter. It would also prevent anyone from knowing, the Secretary of State, local election officials, petition proponents, voters themselves. We wouldn't know the threshold for passage until after the election was over, because it would be dependent on how many people decided to show up the day before.
Yeah.
That's unmanageable.
Yeah.
Any other questions of the witness? Thank you very much, ma'am.
Thank you.
Next person to testify in opposition, please come forward. Bet you have a witness form.
I do. Mr. Chairman, members of the committee, Sam Licklider for Missouri Realtors. We're opposed to all of these. I'm not going to take up a lot of your time because I doubt if I'll change anybody's mind.
Thank you.
I've been
Brutally honest, Sam. You're always brutally honest. Any questions of the witness? Thank you very much.
Thank you.
Next person to testify here in a minute, I'm going to leave. It's not because of something you said.
Good afternoon. Mr. Chairman and members of the committee, my name is Marilyn McLeod. I'm here representing the League of Women Voters of Missouri. And I'll say right up front, the League is totally opposed to all four of these measures. For more than a century, citizen IP process has allowed Missourians to have their voices heard on a range of issues across the political spectrum. Citizens only resort to the IP process when they feel their voice isn't heard. The process is already onerous and mandates a significant showing of voter approval, even to get on the ballot. Between 1910 and 2022, there were 70 measures put on the ballot by initiative petition. 29 passed. In the same time period, the General Assembly put 246 measures on the ballot, and 133 passed. So the Constitution has many measures in it that were presented by the General Assembly. Adding additional burdens to the initiative petition process, which is already so onerous, by either increasing the number of signatures or requiring a two-condition threshold, simply creates issues that you can see that the initiative petition is much harder to do than what the General Assembly does. I don't think that any of these bills that are presented provide any change in the way the General Assembly presents ballot issues. I would like to just ask a question on the Electoral College, if I may. It's always brought up as being the model, but it's possible, it's considered concurrent, but it's possible to have a popular vote majority, but win in the electoral college. And so it's not a requirement to have both. So doing that for the state is unnecessary. Okay, thank you.
Any questions of the witness? Seeing none. Next person in opposition, please come forward.
Ready with the timer? Thank you. My name is Elizabeth Franklin. Thank you for the opportunity to testify this afternoon. I am also here on my own time and to testify in opposition of all 4 of these SJRs. I am glad that there was some discussion earlier, so excuse me for skipping through my notes as questions and other things were discussed, but I am glad to hear that the citizenship language is no longer needed. That was done last year under a Senate substitute for SJR78, and it went on the ballot as Amendment 7 and passed overwhelmingly with 68% of the vote. So changing all to only seems to have resolved that. I am against that kind of language being put into bills periodically. If it is definitely still an issue, make a standalone bill, because that seems to be a very critical issue. But I think it's resolved. And I'm here to help if that help is needed. I know that senators have excellent staff to draft and research this legislation, so I would also say that the foreign involvement that comes up in these SJRs, that's something that also ought to be looked at. I am not sure that that language is still needed. It sounds like from Ms. Lieberman that that is in law. So those things hopefully could be looked at, and I'm sure this body doesn't want anything that falls short of your very high standards to come through. I will mention just quickly that the SJRs and the HJRs, if they are held to a higher standard for passage or signature, that these bodies should hold yourself to the same. That's all I have. Thank you.
Any questions for this witness? Seeing none, thank you very much. Anybody else to testify in opposition? Please come forward and begin when you're ready.
My name is Kay Park. Thank you for listening to me today. I appreciate having a voice, and I think that that's what this is all about. I'm opposing all 4 of these because people have to have a voice. There has to be a way for people to come forward, especially if they feel that legislators aren't listening to them, which happened with Medicaid expansion. That was the only way the people could get their voice, that they could get Medicaid expansion. Reproductive rights as well. And I'm a citizen of St. Louis, and I really feel that this is just really not fair, that you're going to put more credence to a vote in rural areas and not my vote. So it definitely should be the majority rule, not minority. Some of the statistics show that 20% of the vote can actually overrule 80% with some of these changes. And so thank you for listening to my voice. I hope you'll listen to all the voices here. Any questions?
Any questions for the witness? Seeing none, thank you very much. Anybody else to testify in opposition?
Mr. Chairman, members of the committee, my name is Jeff Smith. I'm representing the American Civil Liberties Union of Missouri. We work in the courts, the legislature, and communities to advocate for the rights of individual Missourians, specifically the right to vote. We oppose all 4 of these SJRs for the reasons stated earlier, and would associate our testimony with that of the Missouri Voter Protection Coalition. In particular, the requirements for concurrent majorities in 3 of these 4 SJRs are troubling for the reasons stated by the previous witness. Research has shown that, again, as few as 20% of people could carry the day, over 80% if the concurrent majorities are required in more than half of state legislative districts. The sponsor of one of the bills, Senator Moon, referenced Animal Farm, and a great book, but the propaganda slogan was, 4 legs good, 2 legs bad. We shouldn't be saying that rural voters good, suburban voters bad, or exurban voters good, urban voters bad. Every single voter should be treated equally, and the 3 SJRs that don't do that by requiring separate majorities either of congressional districts or legislative districts. Oop, that scares me. So I'm good. With that, I'd be happy to take any questions.
Any questions for this witness? Seeing none, thank you very much. Anybody else to testify in opposition?
I did one form for each auto agent on behalf of Missouri NEA. I think it was the same committee last year, really coming from the same observation we shared last year. It's understandable that we have seen that when we elect people who run on a partisan basis, and you have a majority and each party clusters around a set of issues, it's going to sometimes happen that the electorate in general, they have to make a choice, but on each particular issue they get to have their opinion, and it might be that the majority of Missourians aren't in alignment with whichever majority party might have. That being said, the Constitution is smart enough in Article 3 to comprehend that the people should reserve the right to enact laws independent of the General Assembly. Now, if you think that the problem, if you observe correctly that there's been a lot of constitutional amendments adopted in recent years, and many of them are quite lengthy and detailed, if you think that's the problem, we would suggest maybe if you take a step back, that might be a symptom. And the problem might be that there's a lack of faith. The people recognize that there are occasionally issues where they're in a different place, but there's a lack of confidence in the use of the statutory IP, which used to be used more often. But when they bother to collect many signatures, it's a lot of work. It takes a lot of money and time to put into building a coalition and having something brought forward. To do it in a statutory IP and then to have the legislature repeal or reverse that, that means maybe you rethink that and you go for the Constitution because it's still a lot of trouble, but then you have something that's harder for the legislature to react to. So our suggestion is, let's look at the statutory IP. Let's look at whether or not, if you said to the voters, if the legislature is going to change a provision done by statutory IP, they're going to send it with a referendum clause and let the people vote on it a second time. We think that would actually restore some more confidence in the statutory IP. That's the problem to address first. Happy to answer any questions.
Any questions for the witness? Seeing none, thank you very
Mr.
much.
Chairman.
Anybody else to testify in opposition?
Thank you. My name is Nancy Ciccone. I'm a Missouri constituent and voter. I'm just a regular person. I agree with all the testimony against all 4 of these SJRs that we've already heard. Rather than reiterate those arguments, I'll just share. As a regular citizen, I've volunteered for multiple IP campaigns that have been popular enough with the people to pass. Again, putting in policies that we Missourians really felt we really needed for our state. I volunteered both collecting signatures. I volunteered also with outreach, talking to voters, letting them know what the issues are once something gets on the ballot. I know from personal experience that this process is already very rigorous. It's very difficult, and appropriately so. I would be very sorry to see any of these provisions that are trying to make this process harder for the people of Missouri to, again, enact policy that they feel they need. And I also wanted to add, I'm thankful for this time to be here to testify with you. I'm taking time off work. I work a demanding full-time job in addition to my personal responsibilities. So I'm also just going to add, I'm against these 4 SJRs. Other provisions that may come up in future that are similarly going to harm our long-standing IP process, I'm also against, and if I'm not able to make it here to testify in that way, just please remember my voice for those provisions also. So again, I ask you not to proceed with these SJRs and listen to the testimony we've heard today. That's all I have to say, but I'm happy to take questions.
Any questions for this witness? Seeing none, thank you very much.
Thank you.
Anybody else in opposition?
Mr. Chair, members of the committee, my name is Ron Berry. I'm here on behalf of Jobs with Justice Voter Action. We want to go on the record and be in opposition to all 4 bills. I would just, offer a word of caution because, as we make these changes, that would apply to anything that has already been passed. So keep that in mind. Also, I'd like to remind you that the money that comes into the state stays in the state. It's spent here. So however much money is spent on an initiative, it goes right back into the state. The other thing that I would like to address is that although the 6th congressional district, the 8th congressional district may not be the total that is turned in, signatures are collected in every congressional district across the state. And I'd be happy to show you proof of that.
Any questions for the witness? Seeing none.
Thank
Thank you. Anybody else to testify in opposition? Seeing none. Anybody for informational purposes only? Seeing none. Do any of the 4 senators have anything they want to say before the committee? Seeing none. Seeing no other business before the Committee on Local Government and Pensions, I move that we adjourn. Do I have a second? All those in favor say aye. And the committee is adjourned.